series of bills that would tighten gun laws in Rhode Island.
Big problem not only for that state, but a bigger problem for a lot of otherwise lawful and responsible gun-owning residents.
Proposal allows for people who own these kinds of firearms before July 1st of 2026 to keep them.
Well, that's exactly what's about to possibly happen in a state out on the East Coast.
Law-abiding firearm owners aren't the problem, and we don't feel like they're addressing the real problem, which is crime and mostly mental illness.
You really need to pick a lane to decide if we're for criminals or against criminals.
Yeah, you're looking at up to 10 years in prison and a $10,000 fine.
If you own an assault-style firearm as of July 1st, 2026.
They just can't section out just certain classes of people just because we own firearms.
Probably in violation of the Fifth Amendment's unconstitutional takings clause, as well as the obvious violations of the Second Amendment.
There's a date circled on the calendar in Rhode Island, and once it arrives, an entire category of firearms that residents could legally walk into a store and buy on a Monday becomes impossible to purchase by Tuesday. That date is July 1st, 2026. But here's the twist that caught a lot of people off guard. The real deadline, the one that actually mattered, quietly slipped past more than a week earlier, and many only realized it when the window had already slammed shut. To understand why, you have to look at the machinery sitting underneath every legal gun sale in the state. Rhode Island runs a mandatory 7-day waiting period, stacked on top of federal and state background paperwork that takes its own time to clear. Do the math, and the picture becomes obvious. If a buyer wanted to legally complete a purchase of one of these now restricted firearms, they could not simply stroll in on the final day and walk out armed. The transaction has to be fully finished, with the physical firearm in the buyer's hands, before the ban switches on. Local dealers spread the warning fast. If the gun is not in your possession by June 30th, the sale is dead on July 1st, no matter when it was paid for, and no matter how badly either side wants to finish it. The commercial pipeline, in other words, went quiet days before the law itself technically took effect. So what exactly is being shut off? This is where the law gets specific, and the details matter more than the headline. Rhode Island does not ban these weapons by name or by brand. It uses what is called a feature-based test, a checklist of characteristics that decides whether a given firearm crosses the line. For rifles, the trigger is a semi-automatic centerfire rifle that can accept a detachable magazine and carries at least one military-style feature. That could be a pistol grip, a folding or telescoping stock, a flash suppressor, a threaded barrel, or a thumbhole stock. Even a fixed magazine rifle gets swept in if it holds more than 10 rounds. For pistols, the test looks for things like a threaded barrel, or a magazine that sits outside the grip, or again a fixed magazine holding more than 10 rounds. For shotguns, it is a fixed magazine capacity above 6 rounds, or the presence of a revolving cylinder. The point of a feature-based law is that it does not chase brand names. It draws a line around a design, and anything that steps over that line falls under the ban. Now, before anyone assumes this means a knock on the door and confiscation, it does not, and this is the part that gets misunderstood constantly. The law targets the sale, the manufacture, the purchase, and the transfer of these firearms. It does not, in its current form, target simple ownership. If a resident already lawfully owned one of these firearms before July 1st, they get to keep it. That protection has a name. It is called the grandfather clause, and it is the single most important detail in the entire story. And the grandfather clause came with its own surprise. An earlier version of the law would have forced every grandfathered owner to register their weapon with state or local police. That requirement was stripped out before the final bill became law, so there is no mandatory registration list. Instead, owners are offered something voluntary, a certificate of possession, available for a $50 fee, and a background check, which exists to create clean, admissible proof that the firearm was lawfully owned before the cutoff. Nobody is required to get one. But for an owner who wants ironclad documentation that they were on the right side of the deadline, it is there as an option. Alongside that comes strict rules on how these firearms must be handled going forward. They have to be stored securely, and they can only be transported in narrow, specific circumstances, such as cased and unloaded on the way to a shooting range or a licensed dealer. Here is where the stakes climb sharply, because the penalties attached to this law are not symbolic. Anyone caught manufacturing, selling, or purchasing one of these banned firearms after the deadline is not looking at a ticket or a fine they can shrug off. They are facing up to 10 years in prison. They are facing fines reaching $10,000. and the firearm itself is subject to permanent forfeiture. That is felony territory, the kind of conviction that follows a person for the rest of their life, costs them their job, and reshapes everything that comes after. So the difference between completing a sale on the right side of a date and the wrong side of it is not a small administrative gap. It is the difference between a lawful purchase and a felony. But if you think this is the end of the story, it is actually closer to the beginning, because there is a second front opening up, and it raises the temperature dramatically. Even as the sales ban takes effect, lawmakers have been pushing a far more aggressive measure. A bill introduced in the 2026 legislative session would do something the current law deliberately avoided. It would ban possession outright. The mechanism is almost startling in its simplicity. The proposal essentially adds a single word, the word possession, to the existing statute. That one word would transform a law about future sales into a law about ownership itself. If it passed, the grandfather clause would evaporate. Current lawful owners would be given a window until December 31st, 2026 to either sell their firearms to a licensed dealer or move them out of state entirely. The people who were promised they could keep what they already owned would suddenly be told the opposite. So why hasn't that already happened? Because this is where the fight got loud. When the relevant committee took up the proposal, along with a stack of other firearms bills, hundreds of people poured into the State House. Second Amendment supporters showed up in yellow, gun safety advocates showed up in red, and the hearing stretched on for nearly 5 hours. At the end of it, the committee made a procedural move with a quiet but enormous consequence. It held the bill for further study. In the language of the legislature, that means the possession ban did not advance out of committee during this round, and that single decision is the reason the grandfather clause remains fully intact for the July 1st rollout. As things stand right now, if a resident legally owned one of these firearms before the deadline, they can keep it, and there is no looming December eviction date hanging over those weapons. The possession ban is not dead, but for the moment it is paused. The broader strategy behind all of this is worth understanding because lawmakers have signaled they are shifting tactics toward the entire mechanics of buying firearms and ammunition, not just the weapons themselves. One proposal would require every prospective gun buyer to complete an 8-hour safety training course featuring live fire instruction and a written exam, expanding a requirement that currently applies only to handgun purchases. Another, scheduled to potentially take effect in the fall, would allow civil lawsuits against firearm manufacturers and retailers when their products are used in crimes, which would pressure businesses to tighten their screening against so-called straw purchasers, people who buy a gun on behalf of someone who legally cannot. And a third would ration purchases altogether, limiting a person to buying no more than one firearm every 30 days. Taken together, these proposals show a clear direction of travel, even if not all of them become law. Hovering above the entire debate is a much bigger question that no state legislature controls, what the nation's highest court will eventually decide. So far, that court has declined to take up direct challenges to these kinds of bans, including an earlier challenge to Rhode Island's own magazine law, effectively leaving lower court decisions standing. But several justices have openly signaled they are willing to revisit the issue, with one suggesting the court may take up the question of these popular semi-automatic rifles within the next term or two, which means the law going into effect right now may not be the final word. It may simply be the current state of a fight that is still very much in motion. So here's the bottom line. As of July 1st, the sale, purchase, manufacture, and transfer of a whole category of semi-automatic firearms is prohibited in the state. The practical deadline to buy one legally had already passed before the law even switched on. Existing owners are protected for now by a grandfather clause that survived a serious attempt to eliminate it. Voluntary certificates exist, mandatory registration does not, and the penalties for getting it wrong reach all the way to a decade behind bars. A possession ban that would erase those protections sits paused but alive, and looming over everything. A Supreme Court that has so far stayed silent may not stay silent forever. For everyone watching this unfold, the only certainty is that the story is far from finished. That's it for today, folks. See you in the next video.